Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, Oregon, we're going to get to do this yet again. Now, I went back and I looked at the channel, and we did our first ever video about Ballot Measure 114 back on November 23rd of 2022. So almost 3 years. And, well, it is finally coming to a head. We are finally ready for the last battle that you could ever possibly have on this, because there really is nowhere else to go once you're done here. I'm talking about the Oregon State Supreme Court. The oral arguments are coming up. Let's go back in our time machine. Let's talk about how we got here, and let's talk about where we may end up. So today, let's spend a few minutes and let's talk about the future of Oregon gun rights sits before its Supreme Court. Okay, America, and in particular, my friends of the South down there in Oregon, it has been a while. Listen, nothing allowed Washington Gun Law to connect with the good folks in Oregon more than Ballot Measure 114, which at the time it came out, I said was the worst piece of gun control legislation I had ever read. Now, I want you to know, Oregon, that it has been outdone multiple times by states that are even crazier than both yours and mine. But as you know, we are both frantically trying to keep up. Let's go back in our time machine. You will remember that the voters narrowly approved Ballot Measure 114 in the 2023 election, okay? The Ballot Measure 114 comes with a magazine ban, it comes with a permit to purchase, and then it also closed the Charleston loophole. We're not going to get too caught up in number 3 today for purposes of trying to keep this video relatively short. Now, lawsuits started flying the minute the ballot measure passed because it had a relatively quick enactment date. One of those lawsuits ended up down in Harney County. And after a full-blown trial before, I believe it was Judge Ratio, the court down there found that the law was in fact in violation of the Oregon state constitution and enjoined it. Now, I want everyone to understand, I said that you're kind of running into the end of the road here, and here's why. This entire challenge and every argument that's ever been made has always been made under the Oregon state constitution, okay? So no one has raised Second Amendment challenges. Now, that's in this case. I'm not saying there's not other Second Amendment challenges to this ridiculous law. But in this case, Arnold v. Kotek, the case that we're talking about today, it is purely under the Oregon state constitution. Of course, you guys all know it's Article 1, Section 27, which reads, "The people shall have the right to bear arms for defense of themselves and the state, but the military shall be kept in strict subordination to the civil power." Okay, but the law was enjoined, right? Yes, except the state of Oregon then crapped their pants and appealed to the Oregon Court of Appeals. Now, they actually applied on 2 separate occasions for emergency stays of the injunction that had been granted out of Harney County. Neither of those were actually granted. However, when the case was argued on the merits, the Oregon Court of Appeals said, we don't see a problem with it whatsoever. And so they reversed the trial court's decision, found no constitutional deficiencies with the law whatsoever, and away we go. So now the petitioners, that is the original plaintiffs in this case, bring this matter to the Oregon Supreme Court, which is now set for oral arguments on November 6th at 9 a.m. Now, as I mentioned, there are 3 components really to Ballot Measure 114, and for purposes of this video, we're going to really focus on the first 2. Just so you guys all know what the Charleston loophole is, it's called that because of a shooting that took place in Charleston. Under federal law, if you pass a certain period of time and the background check has neither been denied nor okayed, the FFLs have the ability, if they so desire, to go ahead and release the firearm to you. Many states have passed laws that say, no, you can't do that. You have to wait until the background check is completed. Thumbs up or thumbs down, no matter how long it takes. That's the issue there. But again, we're going to focus first on the magazine bans, and then we're going to focus on the permit to purchase, because honestly, we know the problem with magazine bans. I want you to understand how abusive permit to purchase can be. And if you don't believe me, just watch any of the videos we've done on the state of Illinois. Now, here's where the state of Oregon comes down on the protection of magazines. Measure 114's restriction on large capacity magazines are facially constitutional. Large capacity magazines are not arms protected by Article 1, Section 27 at all. They are not themselves weapons, and their functionality derives from innovations and military developments that emerged decades after the adoption of that constitutional provision in 1859. Indeed, this court already held that related semi-automatic technology does not warrant protection under Article 1, Section 27. And you sit there and you go, well, wait a second, that's not how I understand Second Amendment jurisprudence. Yeah, that's not how you understand Second Amendment jurisprudence. But what's being argued here is, hey, this is the state constitution, so we don't get into all that Second Amendment case law. No, we get to argue anything under the sun here. Now, in relation to the permit to purchase, here's where the state of Oregon comes down on this. Measure 114's permit to purchase requirements also are facially constitutional. The Supreme Court already has upheld a concealed carry license requirement and process that largely mirror the requirements in process under Measure 114. The reasoning of previous case law applies with equal force here. The policy also is reasonable. The statute requires a background check, an assessment for a disqualifying mental illness, and a demonstration of firearm safety. Evidence shows that such permit programs lead to significant decreases in both homicides and mass shootings. And the provisions do not unduly frustrate armed self-defense. Anyone who meets the criteria may obtain a permit, and any permit holder may acquire any legal firearm. Okay, so now you understand what's at stake here, because that's what the state of Oregon is arguing as it relates to your state rights under Article 1, Section 27, the state equivalent of your Second Amendment rights. Where do the plaintiffs come down? Well, obviously they have a radically different approach to this issue. They start off, though, pointing out that, hey, there's a lot more than just your gun rights at stake. Indeed, despite not being the subject of this appeal, defendants' brief lays bare their goal of declaring semi-automatic firearms, the most common self-defense firearms, unprotected, thereby requiring Oregonians to defend themselves and their state with antiques and calling into question the validity of other rights. How about magazines? Well, we understand the Second Amendment case law. Let's talk about it under Oregon constitutional provisions here, okay? This is what the petitioners argue. Article 1, Section 27 applies to the measure's magazine ban because magazines are part of the firearm. Because Section 11's magazine ban applies to all firearms, there is no need for a firearm-by-firearm historical analog analysis. Nevertheless, historical evidence shows that multi-shot and repeating firearms using magazines were common pre-1859, and technological advancements aim to improve capacity and functionality, reflecting the understanding that such arms are protected. Further, the measure's magazine ban is unconstitutional because it, 1, does not regulate any manner of possession or use of firearms, 2, detracts from public safety, and 3, unduly frustrates the right to bear arms. So listen, Oregon, you got a whole lot at stake. And I know that many of you are really spun up on the magazine ban, and I get that. But I really want you to be aware of how dangerous permit to purchase, because ultimately they turn into permit to possess. And then ultimately they turn into some equivalent of the FOID card that you have out in Illinois. And then your state just randomly through administrative action starts yanking your cards. And once those cards get yanked, now, well, that's subject to a court order to surrender all the firearms, your concealed carry license, everything you may have. So I want you to know that if ever there was a seed that could be planted that turns into a very large tree of civilian disarmament, it is in fact a permit to purchase. Okay, it is Ballot Measure 114. The case again is Arnold v. Kotek, and it is set for argument before the Oregon State Supreme Court November 6th at 9 a.m. If we can find a link for the oral arguments, we'll go ahead and link it up down below so you guys can listen to it live or geek out on it later. If you have any other questions about this or anything else related to what's left of our Second Amendment rights, which in Oregon could be next to nothing pretty soon, you should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everybody remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.